Right now, a dramatic day in the George Zimmerman trial. That is Trayvon Martin's mother faced her son's killer. We will have the latest from Florida. And next, Cardinal Dolan getting some negative attention for unseemly things he allegedly did while in Milwaukee, like moving money around so that sex abuse victims couldn't get at it. We will hear from a former priest who was incensed. And later, is Chris Christie planning to run for president in 2016? And if so, how's that going to impact the way that he governs right now? We'll get into all that and much more, everyone. But first, a good evening and welcome to RFL. I'm Richard French. Thanks so much for joining us this Friday evening, July 5th. And we're going to begin tonight in Florida, where we witnessed dramatic moments in the George Zimmerman murder trial today. Prosecution, they rested after Trayvon Martin's mother and brother testified. And our own Dominic Carter, he joins us now with the latest.
Well, good evening, Richard. The prosecution has concluded their case. The question is, will the six-member, all-female jury buy their argument? Emotional moments as the prosecution winded down its case. Trayvon Martin's mother, Sabrina Fulton, facing George Zimmerman as she took the stand, telling the jury that the screams heard on a 911 call the night of the shooting came from her son.
And who do you recognize that to be, ma'am?
Trayvon Benjamin Martin.
22-year-old Javirus Fulton, Martin's brother, also identified the screaming voice as that of Trayvon. Zimmerman's attorney cross-examined both witnesses, Mark O'Mara pointing out that Javirus initially had doubts if the voice on the tape was his brother's. He also asked Martin's mother if perhaps her son was responsible for what happened.
You certainly hope, as a mom, that your son, Trayvon Martin, would not have done anything that would have led to his own death, correct?
What I hope for is that this would have never happened and he would still be here.
Absolutely.
That's my hope.
Identifying who was screaming on the 911 call could help determine if Zimmerman or Martin was the aggressor during their deadly encounter. And today, startling details about the end of Martin's life. The doctor who performed Martin's autopsy, Sipping Bao, said the teen suffered after Zimmerman shot him through the heart.
I believe Trayvon Martin was alive for 1 to 10 minutes after he was shot.
Originally, Bao concluded that Trayvon may have lived up to 3 minutes. He also changed his mind that the amount of marijuana found in Martin's body affected his behavior. That doctor now thinks Martin's THC level did affect his mental state, but the jurors did not hear about this. The judge ruled it inadmissible. Richard?
All right, Dominic, thank you very much. Let's bring in our panel on this. O'Brien Murray, Republican strategist, Dominic Carter, who you've already met, Doug Von Oist, founding partner of Karts and Von Oist and a former prosecutor on Long Island, Mark Furnish, professor of Brooklyn law and attorney who's argued before the Supreme Court, and Andrew Whitman, our senior political correspondent. All right. Explain to me, to get Doug, a second-degree murder conviction, the standard, because the defense argued for dismissal today. They didn't get it, but they said when you're reaching for this kind of standard, you can't have reasonable doubt here. You can't have, you have to have spite, hatred. There has to be a lot of malice aforethought before it went into it, and they argued before the judge that the case didn't merit it. It is a high standard, isn't it?
Well, I mean, it's the depraved mind that they're looking at. If you simply have a man killing another man with a gun, that's not enough. You need something more, and that's where the series of words that you just said would add up to a depraved mind.
And Mark, to that end, there seemed to be a lot of contradictions during the prosecution's case that they laid out here. Certainly more than we thought had jumped that was going to happen with this case, and the medical examiner today just being the very latest. This has not been an airtight case that the prosecution's laid out. You can argue some of the witnesses did more help for the defense than the prosecution.
Well, none of it is really surprising to me. It's not even close to being airtight. It's porous. And, you know, the standard is so inordinately high, not only because as my colleague said, it's a depraved mind, gross recklessness standard. But the prosecution under Florida law has the added burden of proving beyond a reasonable doubt that Zimmerman did not, I repeat, not act in self-defense. So they have to affirmatively prove a negative, which is one of the most inordinately difficult propositions in American law. And they make no mistake, they knew this about this going into the case, and bringing the case, you know, is A, a form of political cover for them. B, they're giving the case to the jury of our citizens to decide and letting them take responsibility for the verdict. And in the end, it's a very tough case and a very weak case. And that is less the fault of the evidence in the case than the legal standard that they have to meet. It's just an inordinately high standard. And the real question is going to be not whether they can get a second-degree murder conviction, because I think that's a done deal already. It's whether there's going to be a charge down to manslaughter and whether they can get that.
Okay. Doug, there's going to be some questions the defense got to figure out now. And chief among them, at least for me, is Zimmerman going to take the stand? Isn't there an expression that if to get murder, you can't walk if you don't testify, if you're the defendant here? What would you do if you're the defense team for Zimmerman? Do you put him on at this point?
Well, at this point, his defense is already out there. You have an eyewitness saying that he was on the ground being beaten. You have the statements that he made prior to getting an attorney where he says that, you know, basically he's walking around with a bandage on his head and saying that he was being beaten up. So his defense is out there. I mean, the bottom line is if he takes the stand, it no longer is beyond a reasonable doubt. It's do you believe him or do you believe him? So in many cases, you're right. You have to take the stand. You got to put your defense in, especially a defense like this. But this is the unusual case where I don't think he has to. In fact, I think it's dangerous if he does.
You know, Dominic, it seems that this thing's getting telegraphed that second-degree murder is not going to happen right now, barring a huge surprise, and we've been surprised before. Manslaughter looks more practical. We've talked from the beginning that people are looking at this beyond the Sanford community and before the effect of his families. If it goes to a lesser-included charge, and that's what happens at the end of the day, is it enough that so many people have followed this case and they realize that, as he said, there's been porous you know, elements of the prosecution's case? Will the public buy this, or will there be outrage if all that happens at the end of the day, if they're lucky, is if they get a manslaughter conviction?
Well, Richard, understand this is not the first time this has happened in terms of communities of color, the charging of a crime. I recall in Bensonhurst and Howard Beach with Special Prosecutor Charles Hines, and sometimes a prosecutor can overcharge, or the community activists like the Al Sharptons, what they will say in private is, we know we're not getting murder too. There's no way that we're going to get that one. As long as Zimmerman, I'm just telling you from the community's point of view, not necessarily mine, as long as Zimmerman is convicted of something, everything will be fine. If he walks, there's going to be a big problem.
Okay, now.
Well, there's a good chance that he's going to walk, because the manslaughter, understand this, that the self-defense claim is also a defense to manslaughter. So if they don't disprove that self-defense claim beyond a reasonable doubt, legally he's not guilty of manslaughter either. Now, we all know that the law doesn't always control here, and there could be a compromise verdict. And from the defense perspective, I don't want that lesser included offense charged at all. I want to force the prosecution to stand or fall on the second-degree murder charge alone. And if I'm the defense lawyer, I'm going to fight as hard as I can not to get that charge
Now,
down.
Doug, help us here. You're the prosecution. They know the same thing we know, and they know more, right? And the defense hasn't even presented their case yet. So if they think practically, we're not getting murder too, we want manslaughter, what happens behind the scenes right now? And what inevitably happens if they don't work out some plea deal when they're trying to convince the jury? How does it go from this stage now that half the case has been laid out?
Well, you're talking about the charge.
Yeah.
Well, like he said before, the defense, if they smell that they can actually beat the murder too, they're going to say, I don't want manslaughter. You charge murder too? I want murder too. Now, a prosecutor at that point probably, and I think in this case for sure, will say, listen, it's a lesser included, we want manslaughter. And then you have the chance of a compromise, which could have been what was happening here all along by charging murder too. They thought maybe they could get a plea to manslaughter. And that's probably where we are. The only thing I'd say is, even if they didn't charge murder two, everybody would be talking about murder two. If this was a manslaughter case right now, everybody'd say, well, why didn't you charge murder two? So everything's on the table now. You have justifications on the table, self-defense, you've got murder, you've got manslaughter. Now a jury's going to figure it out.
How much does it matter that nobody likes this guy, Zimmerman. I mean, at the end of the day, without, we're past the legalese here part. We're now looking at 6 people in a jury box in Florida, and nobody likes this guy. Everybody knows they told this guy, don't get involved, stand back. And at the end of the day, the kid had a soda and some Skittles, and he was just going home, and he's dead, okay? And all the other stuff is all relevant, but at the end of the day, they don't like this guy who couldn't make it as a cop here and obviously had some baggage, and some 17-year-old kid who never made it home. To the layperson, you say, that's enough for manslaughter. It feels right. So do all parties at the end of the day, are they really going to take a shot here, the defense, to say, you know, 6 people don't like my client, we're going to shoot pool?
Well, I think that's where a lawyer makes his money, probably in jury selection. And we're not talking about that, you didn't see it, but I mean, if they didn't take care of that in jury selection about, listen, you got to do right by a guy that even if you don't like him, there could be a problem. And that's really what we'll never know. I mean, I'll never know.
Well, I'll give you some legalese here, which bears exactly on what you just said. It's called reverse nullification. This is the unusual case where the prosecution and the defense have essentially flipped roles. Usually it's the defense that's trying to get the jury to ignore the law and, you know, decide the case based on emotion, prejudice, like or dislike. In this case, that message is the message that the prosecutors have to telegraph and try to get the jury to do what the defense usually does, that is nullify, to ignore the law and return some kind of conviction simply because this guy is so loathsome. And he is loathsome, make no mistake about it. He's just, in my view, not legally guilty of what he's charged with.
All right, we're at the halfway point here, and I'm going to ask you before we go to break, real quickly, Obi, does this guy walk or does he get convicted of something?
He walks, the civil trial carries on.
He is not walking. There is no way in hell.
I don't know. I suspect he'll be convicted of something, but I don't know. I'm 50-50 right on the fence.
Then to the barristers.
I'm thinking that this case is a mistrial, a hung jury.
Possibly.
If they manage to get the manslaughter charged, you know, as my colleague said, all bets are off. And that, look, that's not chump change. That carries a penalty of up to 15 years. It's a lot of time. So if I'm the defense, I try to roll the dice. I want an all or nothing verdict in this case.
You can never tell what a jury's thinking.
Don't give me that. You're not in Florida right now. You can take a guess.
I mean, I think he should get convicted of something.
I didn't say what should happen. What do you think's going to happen to him?
You know what? I have to look at that jury. I don't know. But
Well, the jury is a convicting jury, the composition of it. There's no question
That's
about
what he
that.
tells his clients. He never knows what a jury's going to do.
You can see the hedging right now going.
You might want to take that plea deal because you never know what the jury's going to do.
All right, we take a break here and we come back switching gears and we turn our attention to an issue much closer to home, and that one of the more popular figures, certainly in recent time, and I argue one of the more talented politicians, but he doesn't run for office. I'm talking about Cardinal Dolan, and he's been getting a whole heap of negative attention for allegations of what he did when he was in Milwaukee, hiding money from sex abuse victims. When we come back, we'll hear from a former priest who was abused himself as a child, now devoting time here to helping other victims. We'll talk about that right after this.